Is someone who drives 30 miles an hour in a 25-mile-an-hour zone, does that person qualify as law-abiding or not?
I think that that wouldn't qualify to the extent that it's classified as a misdemeanor or minor criminal conduct under state law. And I do want to be clear that we certainly think that wouldn't apply under the not responsible category. But if you're focusing on law-abiding in particular, we think that history and tradition there support the conclusion that you can disarm those who have committed serious crimes. So it's not just that any kind of conduct that is an offense would qualify.
Are you making a misdemeanor felony distinction?
That's the line that history and tradition reflect. And so, yes, I think that that is the relevant category with respect to law-abiding citizens. But again, I would just emphasize here we're not directly invoking the law-abiding aspect of the principle because Mr. Rahimi didn't have the kind of criminal record that would justify disarmament on that basis. Instead, our arguments here are directed at the aspect of the standard focused on those who are not responsible.
Responsibility is a very broad concept. I mean, not taking your recycling to the curb on Thursdays. I mean, if it's a serious problem, it's irresponsible. By setting a bad example, by yelling at a basketball game in a particular way. It seems to me that the problem with responsibility is that it's extremely broad, and what seems irresponsible to some people might seem like, well, that's not a big deal to others. So what is the model? I mean, do you go back to what was irresponsible at the common law, or take a poll and see if people think it's irresponsible, to get into a fist fight at a sports event where tempers were running high, or what?
So I want to be really clear that we're not using the term not responsible to describe colloquially anyone who you might describe as demonstrating irresponsibility in many of those contexts that you just described in your hypotheticals. Instead, we read this court's case law, and in particular, its articulation of that principle, we're tracking the court's language here, the principle of responsibility, as being intrinsically tied to the danger you would present if you have access to firearms. And I would draw a parallel here to the principles the court has articulated with respect to sensitive places or with dangerous and unusual weapons. In each of these categories.
Just to be clear, you're using responsible as a placeholder for dangerous with respect to the use of firearms?
Correct. So that's how we understand history and tradition in this context. And the reason that we've used the term not responsible is it's because it's the standard that this court itself has articulated in Heller and repeated in McDonald and then repeated again in Bruin. I think probably the reason the court has used the term not responsible is it gets at the idea that some of the categories of people who can be disarmed might not intend to be dangerous. They might not be culpable in that sense, like the mentally ill or minors. And so I think responsibility gets at the idea that they might not actually intend to be a danger, but in fact would present the danger if they had firearms.